Okay, good afternoon. Our second and last case on the docket today is Dustin Duty versus the state of Florida. That's case number 20-1353. Counsel for the appellant, you may proceed when you're ready.
Thank you. Good afternoon. My name is Craig Trocino. I'm the director of the Miami Law Innocence Clinic on behalf of the appellant Dustin Duty. I'd like to reserve 3 minutes for rebuttal. During the trial in this case, there were at least 7 people in the courtroom who were begging for alibi testimony. The 6 jurors and appellant Mr. Duty. Trial counsel let them all down. He let them down in a case there was a the sole evidence against Mr. Duty was an eyewitness based on a suggestive show-up ID. The jury was so concerned about the level of the state's proof that in an unprecedented move during deliberations, they sent out a question asking the court, quote, was Mr. Duty employed and did he have an alibi? To which the answer was, rely on your recollection of the evidence. Alibi for defense lawyers is the strongest, most capable of all defenses, especially in a case such as this, where you have a suggestive show-up identification. Fred Davis was that actual alibi who was ready, willing, and able to testify and was not called to testify by trial counsel. He wasn't called to testify because trial counsel didn't properly investigate what Mr. Davis was going to say. Under Foster versus Wolfenberger, failing to call an alibi witness, even a poor one, is considered an unreasonable trial strategy and an effective assistance of counsel. So we have to look at what the investigation was that was done here. Now, in a case like this, a court is not only to consider the quantum of evidence known to counsel, but whether that evidence would lead a reasonable attorney to investigate further. And we know from Strickland versus Washington that that amount of evidence also includes what the defendant told counsel. We know from this court, in Morrow versus State, that it can be ineffective for failing to call a witness that casts doubt on a defendant's guilt. There is no type of evidence that casts doubt on a defendant's guilt more so than alibi evidence. So we need to look at what
Counsel, if I could, excuse me, if I could interrupt you briefly. It's my understanding from reviewing the record that there were 2 conversations between defense counsel and Mr. Davis pre-trial, and that the record establishes that Mr. Davis did not say anything about, I'm looking at my phone records, or my phone records show exactly the time the law enforcement call came in. Do you concede that this fact, which is quite important, didn't come out until after the trial?
I do not concede that, Your Honor. And it's important that the record be looked at very closely. If I draw the court's attention to the record on appeal, pages 223 and 224, this is information, and I was just about to get there before Your Honor's question. This is information that trial counsel had 5 days after Mr. Duty's arrest. It's contained in an internal public defender's office investigative report. And in that report, the following information exists: that Mr. Duty was at work with his boss at the time of the crime, that Mr. Duty was dropped off by his boss at approximately 4 o'clock. He was dropped off shirtless, wearing a backpack, a tool belt, and a hammer. He had no hat, no hoodie. He gave Fred Davis's name, saying that Fred Davis is my boss, gave Fred Davis's phone number, and says in there, the police called my boss. And he also says that Mr. Davis's father, and the homeowner for whom they were doing work, all saw him working that day. So now we have to look back at that document, that information that counsel had 5 days post-arrest, and figure out what he did with it. He did absolutely nothing. He waited 3 months.
Well, it seems like the key, at least in terms of, was the crime possibly committed, or was it possible for appellant to have committed the crime based on timeline? That call from law enforcement provides a pinpointed time. Instead of being between 3 and 4, I dropped off. We have a specific time, 30 minutes after I dropped him off, that the police called. So that pinpointed call, that information arose after the trial, or is it your position if a reasonable attorney should have investigated and acquired the phone records pre-trial?
My position is that a reasonable attorney with knowledge that the police called a witness that I'm about to call would ask the question, I see in my notes that you talked to the police. Can you tell me about that conversation? That's what a reasonable attorney would do. Also, a reasonable attorney, when calling a witness 3 months later regarding somebody that witness is only known for 48 hours 3 months ago, and ask the question, when did you drop off this individual? And the response is 3 o'clock, and there's no follow-up. Just like Your Honor's question to me, you're not taking at face value my declaration of the record. You're pushing back on me, and rightly so, because that's what lawyers do in investigation mode. We do not take the first answer. It was 3 o'clock. Thank you, sir. Is there anything that can pinpoint you time? My client says it was closer to 4 o'clock. Can we have a discussion of it? What did the police officer say to you when he called you? Where were you working? What's the name of the homeowner? Are there other people I can talk to? None of those questions were asked. Had even one of them been asked, trial counsel would have been directed more forcefully to the timeline. Beyond the timeline, Your Honor, Mr. Davis has two very critical and very important things that he can offer here. One, the timeline that Your Honor is just talking about. Two, his testimony also radically impeaches the identification, because Mr. Davis's testimony is from the evidentiary hearing is that Mr. Duty exits his vehicle attired nothing like the description that the victim gave. The victim says that it's a 5'11", light-skinned, pale, white male wearing a green hoodie, a red Budweiser cap, and khaki shorts, and that's it. No facial description, nothing unique about his face, according to Ms. Sam. Mr. Davis would have testified that he got out of his car or truck shirtless, no hoodie, no red Budweiser cap, wearing a backpack, a tool belt with a hammer, and I gave him $8 to go. The $8 is important, right? Because when Mr. Duty is found by Officer Taylor, he's found wearing a backpack, a tool belt that Officer Taylor said I had to secure because there was a hammer on it, and for officer safety, rationally, he secured the hammer, right? Taylor says there was no red Budweiser cap, no green hoodie, and there was some change. There was a knife in the backpack, and there was some change in the backpack, and not $155, $2.60, which is the exact amount of change Mr. Duty would have had going from the car to the convenience store, buying a beer and a pack of cigarettes, which is what he was found holding when Officer Taylor found him. So Davis's testimony corroborates everything about what Officer Taylor saw, and none of it is consistent with Sam's description, except for white male, khaki shorts. That's the extent of the match of the description. So had counsel done the investigation, he could have come to two rational conclusions. One, the timeline could have been off. But even if the timeline's not off, it would have impeached the identification. Counsel testified at the evidentiary hearing he didn't put Davis on because he was afraid that he put Mr. Duty at the scene or in the area where the crime happened. Mr. Duty was arrested in the area where the crime happened. The jury already knew that. So a good lawyer, an effective lawyer, a reasonable lawyer would find an argument why he was in the neighborhood and still didn't do this. And that rationale is he's misidentified because he's not dressed anything like the victim says he was. And so that leads me into the suggestiveness of the identification, right? Because this court's held that when you say we have a suspect that's met the description, that adds to suggestiveness. So Ms. Sam was told, we found someone that matches your description. I'll remind the court, her description was 5'11", light-skinned white male, green hoodie, red baseball cap, khaki shorts. What she saw was a white male, no green hoodie, no red baseball cap, a t-shirt, and a declaration that he fit the description. And her testimony was the encounter lasted all of 15 seconds, 25 feet away from a police car window. And he wasn't dressed the same way, but it just resonated with her that it was the same individual. right? Then she asked, where's the green hoodie and the baseball cap? And the police told her, well, that could have been discarded. Well, it also could have never been existed with him too. And they didn't bother telling her that. Then at the police station, as she testified at the evidentiary hearing, she said, did you find my money? And they said, no, but we found drugs in his backpack. So he probably used that to use the money to buy the drugs. That was a lie. That didn't happen for two reasons. One, it's not on the property receipt that was admitted into evidence. And two, Officer Taylor clearly would have testified that I found drugs in his backpack when he searched it. Because he was asked about, did you find a red baseball cap? No, I didn't. Did you find a green hoodie? No, I didn't. And I can virtually guarantee you any officer who's conducting a search of a backpack on the scene pursuant to arrest who finds contraband is going to log it and testify about it later. And Officer Taylor did not. Defense counsel didn't ask him that question, but he didn't know to ask him that question because he wouldn't have, there was no reason to ask that question because there was never any suggestion that Mr. Duty had any drugs. All these different areas of suggestion solidify into the victim's mind that she's got the right person, yet she's still not 100% convinced. You see from the evidentiary hearing testimony, when she's confronted with the knowledge that Mr. Duty did have a job, that he got out of a car, not wearing the clothing that she described, she's shaken in her ability to positively identify him. All of that leads to the inescapable conclusion that the jury was absolutely right to send out that question, is there an alibi? And the resounding answer to that question, is there an alibi, is yes, there is. And trial counsel was ineffective for failing to do it,
Counsel,
even if he thought. Yes.
Did the victim ever say that the assailant had a tool belt on?
No, she did not, Your Honor. She never identified the tool belt and she never identified the backpack.
But when she saw for the 15 seconds through the squad car window, Duty, he had already had that belt taken away, correct?
When she saw him on the show up, he did not have a tool belt or the backpack with him while the show up was going on, but nor did she ever identify that in the initial description of the person who assaulted her.
Okay, so the officer, okay, so let me get this straight. The officers took the backpack from Duty.
Presumably.
Okay.
He was not, he didn't have them on his person during the show up.
Okay, and they took the tool belt.
Presumably.
Neither of those were in the, and those are two things that the victim didn't even see at all at the time she was subject to.
That's correct.
Okay, thank you.
Right, but when Officer Taylor saw him walking down the street, he had the backpack and the tool belt, and the tool belt, according to Officer Taylor, had a very obvious hammer, which for obvious reasons, he wanted to secure and handcuff him before he started, the furthering his investigation, because it could have been used as a weapon. I'm not saying Mr. Duty would have done that, but for an officer safety point of view, that was a rational thing from on Officer Taylor's part. So everybody who saw Mr. Duty before Tiffany Sam did testified that he was shirtless with a backpack and a tool belt, no hoodie, no hat. Davis, Taylor, and then the identification. And I see him into my rebuttal. So if the court doesn't have any other questions, I'll reserve my last 2 minutes for that.
Thank you, counsel.
Thank you.
Counsel for the appellee, you may be muted. Whoops.
Yes, ma'am. I just figured out how to unmute myself. Thank you. May it please the court, Heather Ross for the state of Florida. Here, after the evidentiary hearing from Mr. Davis and Ms. Sams and Mr. Crick, that the trial court found the trial counsel was not ineffective in any of the 4 claims. Defense counsel's decisions, he found not to call Mr. Davis as a witness after investigating him, whether he could be a possible alibi witness, not presenting the interrogation video of appellant in order to impeach the detective to show that he had not continued to investigate past having the appellant arrested, and not filing a motion to suppress the victim's show up identification were all reasonable strategic decisions at trial based on the information he had at the time, and prior to trial and during trial. As to issue 1, Mr. Davis, he was properly investigated. He was spoken to twice, and each time he was adamant it was 3 o'clock. It was 3 o'clock. And defense counsel said, I just can't put him on. He places him at the time before the robbery, and gave him enough time to commit the robbery, go there, go to his friend Polly's house, which he said that he testified, or he said that he told Polly, or he was staying with Polly in the area. So he had enough time to stash the red hat, the gray-green hoodie, and the money, and get back to the convenience store. He had plenty of time of doing this.
Counsel, can you tell me in the record where Crick first became aware that Davis had been contacted by law enforcement that day?
In the record, I would.
Well, did Crick know that Davis had been contacted by law enforcement?
No, sir, he did not. Crick did not hear about the, he testified at the evidentiary hearing that he didn't hear about the potential cell phone call until January. And that's on page 1015 of the record.
Well, let me ask the question this way. Should he have known? Opposing counsel points out I believe it was investigator notes that provided information about the police contacting Mr. Davis.
Well, he knew about it because of the investigation record, but that information was provided by the defendant to the investigator. It was not information that the investigator got from Mr. Davis himself. Once he contacted Mr. Davis was adamant about the 3 o'clock time for drop off. And counselor did not want to put him on there because their defense was the misidentification of the defendant by the victim. And by placing the defendant, by Mr. Davis's testimony, would have placed the defendant at the time with enough time to make the robbery, stash the hat, the gray hoodie, and the money.
Counsel, I think you're missing the point, which is if he had done an adequate investigation, had determined that law enforcement had called Davis, and that Davis, and there was a phone record that shows the phone call around 4:30 something. That whole timeline in defense counsel's mind explodes. It doesn't it?
No, sir, it does not. Once they pulled the phone record and was able to see the phone record, any kind of the information that came in on the record said a blocked call. There was no way they were going to be able to verify that it came from a police officer or Joe Smo or his cousin in Alabama.
But I thought Davis testified to it, and I thought there was an officer that said that he called as well. So would it stand to reason that was the call?
No, the investigator that interviewed Duty testified that he would call him. It never said that he did call him. And
well,
that's
Davis, the employer, said he got a call and talked to an officer, and the officer said, "I've got this guy. He's committed a crime. Have a nice day." So I mean, I'm just struggling. I mean, I would think a defense counsel in this position has this cornucopia of evidence to be able to create an alibi for his client, and it doesn't look like the defense counsel here asked any of those questions or followed up on this information. The idea, in my mind, explain to me how it could be a rational defense strategy to say, well, I can't put on Mr. Davis because that might put my client in that area around that time. Well, that's a foregone issue. There's going to be evidence that the gentleman was arrested around 4 o'clock. So I just don't understand why he didn't follow up with some of this evidence and didn't put on Davis.
Looking at the timeline where Mr. Davis this is the information that Mr. Davis continuously and adamantly said, I dropped him off at 3. If that was what he was going to testify to, the call after the fact, after the robbery, would not have corroborated his alibi or made it even more suitable, because at the time between 3 and 4:30, he was not with him and could not tell. Excuse me, Your Honor, I'm sorry.
You're dodging the point, which is that if an adequate investigation had been done and the follow-up questions had been made to Mr. Davis, and he had said, oh yeah, I got that call and my phone records show it was 4:30. I mean, wouldn't that have altered the whole complexion of this defense here?
No, sir, it would not. It would not have, because he adamantly said he was dropped off at 3. He got a call at 4:32, but the call was blocked. You could not tell what it was saying, who made the call, if it was ingoing or outgoing. And also that just establishes when the defendant basically was arrested, not when he actually committed the crime, which is Mr. Davis was not with him between 3 and 4:30. So it's an incomplete alibi, and no reasonable.
At what time did the crime occur? What was the time of day in San Marco when the crime occurred?
Excuse me, sir, I couldn't hear you.
What was the time of day in San Marco when the crime occurred?
3:30. So it was an incomplete alibi. And so.
But Davis said he dropped him off around 4. So that would be an alibi, wouldn't it?
Yeah, well, that information Mr. Crick did not know until after the evidence, after trial was done, after he had been convicted and come back after being spoken to by the defendant and his mother. That information was not provided to Mr. Crick during trial prep and the trial. He would have, if that had been the case, I'm sure he would have looked into it more. But Mr. Davis was adamant that it was 3 o'clock, and he can't account for the defendant between 3 and 4:30. Now, as to
counsel, I'd like to take you into. Oh, I'm sorry. Just Kim Thomas, please. I apologize.
Go ahead.
Oh, thank you, Chief. Ms. Ross, obviously in these cases, if there's one issue, maybe 2 issues to look at individually, that's one thing. This case to me presents quite the argument, in the very least, of cumulative effect. We've got 3 or 4 different areas of concern. Could you address why wouldn't the cumulative effect of these numerous arguments support Mr. Duty's request for a new trial?
Well, when you're looking at cumulative error, you have to look and see our Florida Supreme Court has, and our federal courts have said that each error has to be found an error for it to be before cumulative error comes into play. And actually here, our Florida Supreme Court said in Parker, where individual claims of error are alleged without merit, the claim of cumulative error is also, error also unnecessarily fails. It's because each one, it has to have an effect on each one. And here, it's just, none of them rise to the level of being errors for ineffective assistance. They don't meet any of the standards for Strickland for deficiency or prejudice.
Okay, counsel, let me focus you on issue 2 and whether or not there was CSE in the record to support the post-conviction court's conclusion that the interrogation video would not have directly impeached Detective Nino. So at trial, detective said something like, I wasn't provided any other names or addresses. Yet if you look at the interrogation video, he appears to have Mr. Davis's business card that was provided. So so help us understand what CSE exists in the record to support the post-conviction court's conclusion in that regard.
Well, the reason why the defense counsel, he testified, the reason why they wanted to call him was to establish that the detective did not investigate any further into the alibi, into other people in this case, looking for other suspects. But so he wanted to put him on specifically for that. Now, putting on the interrogation video, he had to do a balancing test. If you go and listen or read, you see the defendant was very verbally explicit and specifically talking about the victim as well, brought up some things about her, and he was afraid that he was going to rub the jury the wrong way. And he was talking about Mr. Davis, the alibi. He's also talking about Polly, his friend who lived in the neighborhood, that the crime and where he was picked up, actually right around the corner where he was picked up. So he said, I've got to weigh the good and the bad. Am I going to put this on, or am I going to just basically put the detective on and find out that he didn't investigate any further? And really, the investigator, he answered him honestly, no, I did not investigate any further. And so there was no reason for him to impeach the witness. And the trial court, the evidentiary trial court, said this was an insignificant matter, that it clearly, the detective's testimony clearly said, I did not investigate anywhere further, so there was no reason for him to try to impeach him. Now, as of issue 3, I have 2 minutes left. Okay, opposing counsel has muddied the water when it comes to the timeline of what Mrs. Sams knew at the time when she came for the show up. All that she heard from the detective, which she testified to in her deposition testimony, which she was questioned by defense counsel, officer said, we have someone who matches your description. Will you come and do a quick ID? She doesn't say anything else. They pull up in the cruiser. She looks through the windshield. The officer looks at her and says, does this look like him, Is that him? And she goes, absolutely. At that point, defendant was arrested. She was taken to both of them were taken to the police station. And at the police station is when she found out, oh, he had a backpack. He had a knife. We didn't find the money. We didn't do this. So all of this information came in way after anything about the show up. And she had a very close encounter. He came up to her, grabbed her by the arm, spun her around, and put a knife to her neck. I would think that she'd be staring right at him. So if the court doesn't have any more questions, the state would ask you to affirm the denial of the post-conviction motion. Thank you. Have a good day.
Thank you, counsel. Counsel for the appellant.
In point in fact, she was not staring right at him, and her testimony confirms that. She said she had just received a job offer. She was looking down at her telephone, texting her boyfriend, when the person came up from behind her. She was distracted. She was looking at her cell phone, and then she was looking at a knife. She never was looking right at him. She never testified that. I don't believe that's anywhere in the record. So there's a lot of information about eyewitness identification. That weapons focus that the Florida Supreme Court has recognized distracts one's attention. Looking at your cell phone distracts one's attention. That's why there's laws that you shouldn't text and drive, because it's not safe. Walking and texting is just a little more safe, but still not great as far as seeing your surroundings on that. With regard to the suggestion that Mr. Davis was, quote, adamant about the 3 o'clock, the word adamant was only uttered by defense counsel in reference to that. It's funny that he says Mr. Davis was adamant, yet he never asked Mr. Davis, are you sure? And if you want to see a declaration of adamance, then read Mr. Duty's letters that are admitted into evidence and the transcription or the video of his interrogation, where he says 13 different times, "I did not do that. Please call my boss. He will tell you I'm working for him." That's the definition of adamant, not 3 months hence, "I think I dropped him off at 3 o'clock." With regard to Detective Nieto, absolutely, that was directly impeaching. He said, "I was not given anything like that, names or addresses or anything like that." He was given a ton of anything like that. And the trial court was incorrect in ruling that way. And I do believe,
Counsel,
yes, Your
quickly.
Honor.
I'm sorry, Counsel, quickly, could you give us, if you know, could you give us a record site? Judge Makar asked the question, what time the crime occurred? Could you give us reference to any documents that pinpoint the exact time the crime occurred?
Certainly. I don't have the actual trial record site at my fingertips, but Ms. Sam testified that, and the 911 call comes in at approximately 3:37 p.m. And she testified it took her about 5 minutes to get from the street level up to her apartment to make the call. So 3:32, 3:33 is the best guess of when the crime occurred, according to when the timestamp of the 911 operator who said they got the call at 3:37.
Okay, thank you. Because I looked in the record for an arrest record, and I didn't see it. It didn't answer that question for me. So thank you.
Yes, it would be. It's definitely with regard to what Ms. Sams testifies, how long it took her to get from street level to her apartment, and in reference to the 911 operator's declaration of exactly the time when the call came in, and that was 3:30. The call came in to 911 at 3:37. I see that I'm out of time.
You may briefly conclude. Thank you.
Thank you, Your Honor. I would just like to conclude that saying that trial counsel was rendered horribly deficient performance in 3 different ways: by not calling the alibi, by failing to move to suppress the suggestive show-up identification, and by failing to impeach Detective Nieto. Each one of them by themselves are deficient performance and cause prejudice, such that but for that deficient performance, the outcome of the trial would have been different. And I agree with Judge Thomas's declaration that this is probably a cumulative error thing as well. So I would ask this court to please reverse the trial court and remand this matter for a new trial. Thank you.
Thank you. Thank you. Thank you to both counsel. Have a good afternoon. The court is adjourned.